Good evening, everyone, and welcome to the Southwest Side Housing Know Your Rights event. My name is Martin Cazzola. I am a supervising attorney at Chicago Volunteer Legal Services. I'm joined by colleagues from Lawyers Committee for Better Housing and Greater Chicago Legal Clinic. Some ground rules at the start of this presentation on rental housing. This is a general information session only. For specific information about your situation, please consult an attorney. Contact information for each organization will be provided. In addition, local rules can change. We will be talking mostly about the rules in Chicago. We're going to cover three main topics. One, the current eviction process. Two, physical and utility lockouts, including heat, electricity, and water. And three, eviction case sealing. I'll start by talking about the current eviction process. Every eviction case has 6 steps. A landlord cannot evict a tenant unless the landlord follows all 6 steps. Step 1 is proper notice. Step 2 is filing the case with the court. Step 3 is serving the tenant with the court case. Step 4 are the initial court dates or status hearings. Step 5 is the eviction trial. And step 6 is enforcement of the eviction order. We will talk about the eviction process and changes to the process caused by COVID-19 in that order. So step 1 is the notice of eviction. In situations involving allegations of non-payment of rent, landlords are required to give a minimum of 5-day notice. For violations of the lease, those require a minimum of a 10-day notice. For terminating a tenancy, that depends on the length of the tenancy. First, we'll talk about non-payment of rent notices. These notices require a minimum of 5-day notice in writing. If the tenant has the funds, they should pay the full amount to their landlord. It is mandatory for a landlord to accept full payment. If a tenant has a portion of the full amount due, they can try paying a portion. The landlord does not have to accept this amount, but if they do, they may still continue the lawsuit. The second type of notice is a violation or a lease violation notice. This requires a minimum of 10 days notice in writing. The landlord is saying that the tenant is doing something that violates the lease agreement or there is conduct that needs to stop. A tenant can cure a 10-day notice by writing a letter to the landlord. They can get assistance with this at www.rentervention.com, which can be used for assistance in writing a cure letter. The third type of notice is termination of a tenancy. If there is a lease, the landlord must notify a tenant if they do not intend to renew the lease at the end of the lease period. If the tenancy is month to month, landlords must give a minimum notice for the termination of tenancy. The length of the notice period is dependent on the length of the tenancy. Landlords do not need a reason to terminate the tenancy with a non-renewal notice, but they do need to provide a tenant with a written notice. The same rules apply if the landlord wants to raise a tenant's rent. In order to figure out how much notice is required, you need to look at the length that you as the tenant or your tenant, if you're the landlord, has been there. For tenancies of less than 6 months, you're required to give a minimum of 30 days notice in the city of Chicago. For tenancies between 6 months up to 3 years, you're required to give a minimum of 60 days notice. And for tenancies of more than 3 years, landlords are required to give 120 days of notice in the notice of termination. If a landlord gives their tenant the wrong notice, the notice starts from the day the tenant receives it, but extends to the correct number of days. For example, a tenant has lived in an apartment for 4 years under a month-to-month lease. The landlord gives the tenant a 30-day notice on August 1st. Those tenants have until December 31st to vacate because the tenant is entitled to 120 days under city ordinances. This same rule applies if the landlord wishes to raise the tenant's rent. Step 2 in the eviction process is the filing of a court case. Nothing prevents a landlord from filing an eviction case now, after they have served a valid notice. However, a landlord who has applied to the Illinois Rental Payment Program has agreed not to file a court case. When filing, landlords must attach a copy of the eviction notice or demand upon which the case is based, an affidavit of service of the notice, the lease or parts of the lease if the case is based on a lease violation, and a county flyer with information about rental assistance in the early resolution program. Step 3 is the service of the summons. Tenants have the right to be served a summons. Summons will include information about the tenant's first court date, court-based resources, and allegations that the landlord is making against the tenant. Summons are typically served by the sheriff or a special process server, although they may be served by alternate means with the judge's approval. The summons may be left with anyone residing in the household 13 years or older. If you are served and you're a tenant, you should call an attorney as soon as possible. Step 4 in the eviction process are the initial court dates or statuses. Tenants should appear at the first court date that they are aware of from summons that is served on them. Zoom information will be included on the summons, and the clerk of court and chief judge have Zoom information on their websites. If you don't have a computer, parties can call or access Zoom via by dialing in using a phone. Alternatively, if the parties can't access Zoom, they can go to the physical courthouse on the summons, and court staff will help you access Zoom. Tenants have a right to trial by jury of their peers, which they should request at an initial court date. And parties can request a translator in court, which would be paid for and provided by the court. As part of the initial court dates, you as a landlord or a tenant have access to the early resolution program. At these first court dates, you can request from the judge to be referred to the early resolution program, sometimes called ERP. This program will put parties in touch with a free attorney to advise them about their case and potentially represent them in negotiation or mediation to resolve the case outside of court. In addition, there is court-based rental assistance available through the ERP, which should be expedited funding that is tendered while the case is pending. Step 5 in the eviction process is the actual trial. Eviction trials can happen in front of a judge or a judge and jury. It is best to have an attorney before trial because there are rules for presenting evidence. Trials by a judge only, or otherwise known as a bench trial, are somewhat informal. The landlord provides testimony about serving the notice and the actions by the tenant that are the basis of the notice, i.e., how much rent is unpaid if the case is about rent. And then the tenant can provide testimony and documents about defenses to the landlord's claims. Bench trials are currently happening both in person or by Zoom. Jury trials are more complicated and are difficult for landlords or tenants representing themselves. In jury trials, both sides can present documents and testimony, but it's a much more formal process. Jury trials will almost always be in person and can take longer to schedule. Step 6 in the eviction process is the enforcement of the eviction order. As of right now, sheriff deputies are currently enforcing eviction orders. It's important to note that only a sheriff deputy can actually execute an eviction order, and that even with a valid order in hand, a landlord cannot change the locks on the property or the rental unit until the deputy arrives. If a landlord changes the locks early, a tenant should call the police immediately. The sheriff does not evict people when it's under 15 degrees or during severe weather conditions, regardless of the temperature. In addition, the sheriff has an eviction social services unit to provide assistance to individuals who are elderly, mentally ill, physically disabled, and families with very young children. For more information on this unit, you should call 312-603-3337. As part of all eviction cases right now, both landlords and tenants and homeowners can speak with a lawyer for free through the Cook County Legal Aid for Housing and Debt program. The Early Resolution Program is part of Cook County Legal Aid for Housing and Debt, otherwise known as CLAD. CLAD attorneys can help landlords and tenants prepare court documents so that all rules are followed, and also provide mediation services between landlord and tenants through CLAD. The goal of mediation through CLAD is for both parties to agree on a path forward. And in the case of a rental disagreement, that may include reducing rent each month, coming up with a structured move-out plan, or other arrangements. Landlords and tenants do not need to wait until an eviction case is filed to get early resolution services, and you can call 855-956-5763 or visit cookcountylegalaid.org to get access to this program. With that, I'll turn it over to another attorney to talk about physical and utility lockouts.
I am Adam Salzman, Executive Director of Greater Chicago Legal Clinic, and I'll be discussing physical and utility lockouts, specifically heat, electricity, and water. What do you do if your landlord shuts off your utilities and or locks you out of your home? First of all, a lockout is when a landlord changes the locks, removes tenant's property from the unit, or shuts off utilities. A lockout is a crime. From September 15th to June 1st, the temperature inside a rental residence is required to be at least 68 degrees Fahrenheit from 8:30 a.m. to 10:30 p.m. and at least 66 degrees Fahrenheit from 10:30 p.m. to 8:30 a.m. Landlords face a fine of up to $1,000 per day per violation for each day they do not supply adequate heat. The reason for lack of heat does not matter. Landlords must follow the law and apartments must be heated. If a landlord is not providing adequate heat or no heat at all, you may file a complaint via via Chicago's 311 website or via mobile app by calling 311. The Department of Buildings will inspect your unit and will take action against delinquent owners. If the landlord wants to evict you, they must follow the proper procedures and file an eviction case. If your landlord lives or is present on the property, call the police. Write the names and badge numbers of each officer that shows up. And when the police arrive, notify them of the utility shutoff or lockout. Make sure to use the word lockout in the conversation. Request the police to order your landlord to turn on the utilities and or provide keys to the unit. Request a police report. And if they don't provide a police report, you can request an ordinance complaint form. If your landlord does not live nor is present on the property, go to the police station in the district of your residence. Obtain an arrest warrant against your landlord. And when you go to the police station, write the names and badge numbers of each officer you speak with. If the police aren't helping, you can go up the chain of command. You can ask for a supervisor. Write the supervisor's name and badge number. If the supervisor is still unhelpful, ask for the watch commander. Write the watch commander's name and badge number. You can refer every officer to the Residential Landlord Tenant Ordinance Section 5-12-160 and Special Order S040103, subsection 4. If all else fails, file a complaint with the Chicago Police Department Internal Affairs Division, Office of Professional Standards, 1130 South Wabash, 4th floor, Chicago, Illinois, 60605. Attention to the intake unit, and their phone number is 312-747-6307. And you should also contact the following agencies about your issue. Civilian Office of Police Accountability, that's COPA, 312-745-3598. And also the Chicago Police Accountability Task Force. And you can email them at comments@chicagopatf.org. An important note, it's unfortunately very common for the police not to help tenants when their landlords break the law. It is a gross and systemic injustice, and it's important that we all bring it to the forefront to hold police and landlords accountable. And this is why it's very important to record all of your interactions with the police, as well as their identities, their names, and their badge numbers. If the police dismiss you by saying it's a civil matter and there's nothing they can do, stay strong and hold your ground, because they are wrong. You can also alert your local alderman. It may be helpful to alert your local alderman to the issue, as they likely have a constituent services staff member who can help guide you to the resources you need, or it can also help you contact the police if you feel nervous about calling them yourself. You can search for your local alderman's name and office number by entering your address at the URL below. And of course, you can get legal help. You may need a legal advocate or a letter documenting the lockout or the utility shutout. And to do that, you can use www.rentervention.com to generate a letter using the proper legal language and options, and mail the letter to your landlord with a record to you free of charge. You can call Lawyers Committee for Better Housing if you're not able to use the virtual clinic at 312-347-7600. Thank you, and now I'll hand it over to my colleague.
Hello, my name is Antoinette Bowles. I am a staff attorney with the Lawyers Committee for Better Housing, and I will be discussing eviction ceilings. So how tenant screening reports back make it hard for people to bounce back. If you have an eviction on your record, it holds an enormous sway over future landlords and future, rent checks. And they can go on your credit reports. These credit reports, they often include, just simple thumbs up or thumbs down as to whether they recommend a landlord to rent to you in the future. And this can hold huge sway over your ability to rent or obtain housing in the future. In a credit report like that shows your eviction, it might not matter if the eviction proceeding was handled correctly or even if you won the case. Many times a landlord might just file an eviction but won't finish or go through with it, and you won't actually be evicted. But the fact that the landlord filed an eviction against a tenant is still on the record, and that can still be held against you in a credit application and hurt your prospects for future housing. In the city of Chicago, about 40% of evictions filed in Chicago do not result in eviction or an order against the tenant, which means 40% are filed, but there's no eviction, and those 40% are still often on your record. Fortunately, the state of Illinois has a new ceiling statute in place. This new law relaxes the standard of sealing evictions, but it is only until July 31st, 2022. And it further qualifies for sealing old evictions, as well as newer evictions that were filed during COVID. In order to qualify for sealing an old eviction from before COVID-19, there needs to be 4 qualifications to meet. This is a copy of the statute for sealing old evictions. We'll go over each qualifier one by one and to help break it down. Okay, so the first qualifier is, was the eviction case dismissed? Does not matter whether it was with or without prejudice, just was the case dismissed? An example is the landlord was not able to get the sheriff to serve the court papers and just stopped trying. And the landlord did not go to court, and the judge dismissed the case because the landlord wasn't trying to actively prosecute. In court, this is called dismissed for want of prosecution. If the landlord and tenant work out a deal, that case would also be dismissed if the tenant moved. As long as the matter was dismissed, the record could be sealed. The second type, which is number 3 in the statute, is that there was no material violation of the terms of the tenancy by the tenant. So an example of this is the landlord based the case on the end of the lease and the tenant was not able to move quickly enough, such as during a 30-day notice. And the landlord did not list any cause on the form complaint. And the case was a bank case against the tenants in the foreclosed property. So basically it means, and the judge decided the landlord did not prove its case. So an example of that would be if the landlord was alleging that the tenant owed rent and the tenant did not in fact owe any rent, the tenant was up to date, that would be an example that there was no actual breach of the tenancy. The third way it can be sealed is the parties to the eviction action both agree to seal the court file. An example is the tenant has paid all of the judgment and previously got a release and satisfaction of judgment. Or the tenant pays some of the judgment and the landlord agrees to seal. The sealing does not affect if the tenant still owes money to the landlord. It's basically as long as both the landlord and the tenant agree to seal, then the case is likely to be sealed. And the last way to get your case sealed is if it's in the interest of justice and sealing, the court file outweighs the public interest in maintaining a public record. Examples include the tenant was going through bad times or hardships such as a divorce or domestic violence and has a good explanation. The tenant has changed other things in their life, but the eviction record is still dragging down their ability to find decent housing or anything else. You can go to rentervention.com to see if you qualify for an eviction sealing, and Rentervention will also help you draft a motion to seal for your case. In order to start a motion, these are the following details that you will need to begin your motion. First, you need your landlord's name. If they're a company, then you need to use their company name. Then, of course, your name, your case number, the courtroom that it was in, the date that the original eviction was filed, the last date that it ended, and the overall outcome of the case. In order to file it, you can go to the Clerk of Cook County website and look up their case information where the arrow is pointing, where it says to look up case info. And then you go to the online case search and you look at the civil law, chancery, domestic relations, support search to start your search. Make sure that when you select your division, you select the civil division. If you do not know your case number, you can search by your name. You just click on the defendant option and type your last name first and then your first name with no commas. You can find your actions after the search. They'll be identifiable with either joint action or a forcible entry and detainer. Here you can, once you click on your case, you can look to see the status of it. So here, if we look at this case, you can see that it was filed around May 10th, 2018, and that the case was dismissed around May 30th, 2018. So a case like this would be ripe for sealing. To file, you have a couple options for filing. The first option is you can go in person to the clerk's office. It's on the 6th floor of the Daly Center, which is 50 West Washington, or you could file electronically through Odyssey e-file. You can also go to the Rentervention virtual clinic, or you can call Justice Court for help and information to help you file. This is Justice Corps' phone number. If you have any questions about filing or need any help filing, you can call them at 872-529-1093. Some of the documents that you will need. If you're filing in person, you're going to need an exemption from e-filing. If you're experiencing hardship, you're going to need an application for a waiver of court fees. You can get these at Illinois Legal Aid online for a fee waiver. They have easy forms for you to fill out. You must get an order for a waiver of court fees, notice of motion and proof of delivery. So if you're trying to get your file sealed, you have to notify the landlord and prove that you notified the landlord, and the actual motion to seal. Some exhibits you might include are the 30-day notice, the dismissal order, release and satisfaction, or a contract, or an affidavit. Especially if it's a case for the interest of justice, you might want to include the affidavit to explain some hardships that you might have gone through, and a return receipt for certified mail showing that you had notified your landlord, and a copy of the sealing order. It's important to mail to the landlord or the landlord's attorney. Again, it's very recommended that you certified mail, because then there is a record showing that it was delivered and when it was delivered. Tips for appearing in court. Again, be on time. Currently, a lot of courts are on Zoom, so still be on time for the Zoom court. Prepare what you are going to say and practice it. And be prepared that the motion might be continued, especially if the landlord does not appear or show up. It may very well be continued, or they might want time to respond. When it might be better to have an attorney. If the tenant really does not know anything about the case, so say the tenant was never served and has no knowledge of the eviction against them, this is quite common. If the tenant only has an interest of justice argument, it might be a bit harder to seal, so it might be good to have an attorney. Or if the tenant has difficulty working with technology. As I said earlier, a lot of these court hearings are held via Zoom. Make sure to address in all orders sent to the clerk. Make sure the email address is on all orders sent to the court and clerk. This includes both email addresses, your address as well as your landlord's or your landlord's attorney's email address. Wait for the stamped order back from the court. Run the name and case number search to check whether the case is still publicly available, and request credit reports and or tenant screening agency reports, and follow the dispute process if the case is still showing up. For free legal services, you can call these following agencies: Cook County Legal Aid for housing and debt, serving all of Cook County residents and property owners regardless of income, language, or immigration status. You can call them at 855-956-5763 or go to cookcountylegalaid.org. You may also call the Lawyers Committee for Better Housing, serving Chicago market rate tenants. You can reach us at 312-347-7600 or visit our website at www.lcbh.org. You can also visit rentervention.com for help with cure letters or motions to seal and various other services. We have languages available in both Mandarin and Spanish. Translators for all other languages are available upon request. You can also go to the Chicago Volunteer Legal Services, serving landlords through CCLAD 855-956-5763 or cookcountylegalaid.org. And finally, you may also visit the Greater Chicago Legal Clinic, which serves Cook and Kane County tenants. 773-784-2900 or email them at evictionhelp@chinesemutualaid.org. They have languages available in Chinese, Mandarin, Cantonese, Burmese, Vietnamese, Tagalog, Hmong, and Spanish. And translators for all other languages are available upon request.